Hey everyone, I'm Leonard French, and I just heard about the h3h3 lawsuit from Matt. Oh, I'm not even going to pronounce it. Matt Haas, I guess, is what everyone calls him. This is something that I was a little concerned about. The way content is used on the internet in various ways, it opens this sort of thing up to that sort of claim. I'm not saying that this claim is necessarily going to succeed. I have some comments on that in a moment, and I also want to refrain from giving h3h3 direct legal advice through a video here. If they would like some representation or a second opinion or something like that, I'm certainly open to talking to them, but no one should act upon anything I'm saying in this video without talking to their attorney first. Okay, let's make that clear. So yeah, even if it's fair use, you can still get this kind of claim, and this kind of claim can cost a lot of money. This is a fairly typical copyright complaint that I would expect in a YouTube content creator fair use debate. Some of the things that are in the lawsuit are quite hyperbolic, and I would expect that. Remember, we're in an American court of law where the court expects each party to present their case in the most hyperbolic manner, and it will be up to the court and the jury to decide exactly what's true and what's not true. Of course, a plaintiff's attorney is not going to lead with conciliation and middle ground and agreement. I do not agree with the tactics of Mr. Booker here from Thompson Booker LLP, but if one was to represent a claim, this is the way one would do it. So I'm not saying anything about the procedure or what that he's using here. This is more or less the way that one would go about it. The claim itself, I think, is a fairly empty claim just on its face. However, it's an unresolved point of law. How much of a YouTube video can you use before you're responsible for licensing it? And that's going to be decided in this case. Or, much more likely, the parties might find a way to settle the thing after some things get shaken out here. What they have in store for them, I'm looking at the court docket here, and I'll bring it up on my video when I put it together. The court docket, this case was just filed on the 26th of April. It's not even been a month. It's been about a month. No one has actually been served with a copy of the complaint, or rather, let me correct that. The return of service has not been entered on the docket, so that means we don't have an official response date for the defendant yet. But I'm assuming, based on what was said in h3h3's video, an attorney, whether it be Ryan Morrison or one of his associates or someone else, will be entering their appearance in the case and will be responding to that amended complaint. Let's take a look at the amended complaint. Where the hell did I put it? There's only two claims for relief in the complaint. One is the copyright infringement, which they are claiming is not a fair use and therefore constitutes some kind of claim for damages. The first claim is just copyright infringement, plain and simple, and I expect that that would get resolved by a judge, by a jury, by an arbitration panel, depending upon which judge did they get here. KBF, Catherine Forrest. I don't know her. I'll have to look her up. Judge Catherine Forrest. Oh, she's cute. Don't threaten a federal judge. Okay, yeah. What does Above the Law have to say about her? Oh, she's the Silk Road judge. Of course she got death threats in the Silk Road case. That's Silk Road. And anonymous. Everybody thinks they're anonymous. Yeah, she was the one who apparently put away Ross Ulbricht in some way. So it's not like Judge Forrest is going to see all of this and not understand what the true underlying dispute is. Just like in my case a few years ago. The judge basically, how to put it, the judge encouraged us to pursue arbitration. And I'll leave it at that. The second claim for relief here is that, oh, it's a 512F misrepresentation. Okay, so this is the normal thing that I would expect if there was an accusation for copyright infringement for a dispute over fair use of a YouTube video. What does it cost? Ethan's absolutely right. It can cost $100,000. That's a big figure, but it's a high figure as in estimate. But yeah, when you're giving a client an estimate of what the total costs could be, if plaintiff's attorney tries to put defendant through all the hell he can, yeah, you could easily get a $50,000 legal bill or more. If you hire an expensive attorney, and the more experienced the attorney, the more money they're going to want, you could easily get a $50,000 or $100,000 legal bill. Well, plaintiff's got an uphill battle here. They have to prove a knowing misrepresentation on Ethan's part. That's going to be difficult. And they're going to have to prove the copyright infringement. That's not going to be difficult to prove that copying happened. Whether it's infringement is going to be a factual determination for the court, or a legal determination for the court or the jury to decide, if it gets that far. It will be very interesting for all the rest of us, I'm sure. It will not be fun for Ethan and, is it Hila? It's never fun to be the one in the middle of these court cases, even if you believe in the cause you're fighting for and you believe that you have a good case. It is still not ever fun for the defendant. I'm sorry to hear that this has happened. Honestly, it couldn't have happened to a nicer guy, from what I've seen of Ethan. Filing a lawsuit like this opens the plaintiff up to counterclaims by the defendant as well. So anything from malicious prosecution to a 512F misrepresentation in the opposite direction, those things are now on the table. And Ethan and Hila can talk to their attorney about their options and whether those are a good idea or not. The defendants, in any whatever the case is, defendants always have to respond with their basic defense. That's the very first thing they'll have to do. And then, once the judge has this initial pretrial conference, there will be an opening of the discovery period where the parties will have a chance to request documents and things and testimony and admissions and anything that I just listed, if it is related to the claims or defenses by making them more likely or less likely to be true, or as in relevance, then those things will be discoverable. And this can be a very expensive part of the case. The plaintiffs and defendants will have to go through the requests, the various requests, and do their very best to respond with all of the electronic or paper or testimonial evidence that they have, that they think is responsive. They'll have to go over it with their attorney. It's very time intensive. If it's a large corporation that's getting sued. It can be very document intensive. Even H3h3 is a fairly high quality production. I'm sure that there's going to be at least discovery of video evidence, probably some discovery of emails and messages and things to basically, it sounds like a fishing expedition, but to a point it's allowed in a civil case. Then after the discovery period, the parties will probably have some sort of motions for the court to help refine some of the issues or possibly even eliminate some of the issues. If enough discovery was done that a party thinks they can prove their case, they can file a motion for summary judgment, and some of the issues can be defined or resolved before they get even to a judge or jury decision on the thing. And then if it really needs to, if there are any what we call material issues to be resolved at trial, then those issues are presented to a judge and then to a jury in a procedural way for them to decide whether those things are a valid claim of copyright infringement in this case or not. And then there's a secondary part that's damages, and this is the part that I'm a little concerned about here, because I know a lot of claims were made in this complaint about damages, and I skipped over them because I don't give them a whole lot of weight. There's certainly an argument to be made that some sort of damages occurred if this really was copyright infringement, but it can't possibly be that much. So, well, I'm assuming that's going to also be part of the factual determination of the plaintiff and the defendant and the jury and the judge, who is. Now this does say it's copyrighted. He's copyrighted all these titles as one registration, so that could be an argument there as well, whether you infringed upon one work or all of these works separately. So I think you're going to have. I think the plaintiff is going to have trouble at the damages section at the very least, even if the judge or jury was to agree that it's copyright infringement. But I'm not 100% on that it's copyright infringement. That's a much longer analysis than I'm going to do tonight. I haven't even seen the 3 minutes or whatever of the video that were used. So, it's a sucky situation for any defendant that finds himself in a situation like this. That I've seen hundreds of times before, and it's never something that even for my own sake, I do not wish these things on defendants. Even when I'm getting paid, I'm grateful to be getting paid. I'm happy to have a job, and I'm sure the student loan company is happy to get paid too. But I don't wish these things on anyone. If these were large, wealthy parties who could afford to have these disputes in court, or if the court system was set up in a way that these disputes could be more affordable for parties that don't have a ton of funds, great. But as it is, this is intellectual property, and attorneys want more money than they want for your local family law dispute or traffic citation. We'll see what happens. I don't think this is going to play out nearly as complicated as it could. But that is partly up to plaintiff's attorney and partly up to the court. My first curiosity is exactly how Judge Forrest is going to respond at this meeting on Thursday, June 16th. It's a pretrial conference, so I don't think it's open doors, otherwise I would be there. I am always fascinated by the academia of copyright law by the ins and outs of it, the what have yous, the... Okay, I'll stop there. Yeah, I'm really curious what Judge Forrest is going to do after this initial pretrial conference. So anyway, thank you for watching. I'm sorry it wasn't under better circumstances, as I find myself saying too often these days. I'm Leonard French. I'll probably follow this up with some kind of update under more prepared circumstances. I do have some other videos coming up, I swear. I will get my prosecutorial discretion video done. I want to tell you all about what happened at, was it UC Davis? Which I'm sure you already know, but let's talk about the legal, about how the officer got away with his pension intact and I believe a $38,000 settlement. And a bunch of other stuff. So, I'm out for tonight. Have a good night, and I'm sure I'll have an update for you later.